Okay, Year 12. Today we're working on a really important skill that we use often in the law, and that is interpreting judicial reasoning. And the reason why we want to use this skill is so that when we come to judgments, firstly we can understand the reasons for a judgment in a particular case, we can understand how the law has been applied, and very importantly, we can understand how it is going to be applied to future cases. What is the effect of the reasoning? Now, in the law, we need to use this strategy every time we approach a judgment. It is the core skill. And I want you to think about this skill as searching for the key, okay? If we can find within this judgment, and sometimes it's like finding a needle in a haystack in many ways, but if we can find that needle, it becomes the key to understanding how this law impacts society, to understanding how it might apply in future situations. Okay, so let's begin. I think it's, before we start to get into the judicial reasoning, let's just make a note that this is in the Supreme Court of Victoria, which is a superior court. And therefore, in the reasoning, if it's going to be bound by a previous decision, it will be bound by the decisions of the High Court. We may find some persuasive precedent in this text as well. Also important to note that the decision of the court in this case will form binding precedent on the county court and the magistrates court moving forward. So immediately I'm thinking that from this decision perhaps a fairly significant legal precedent may be set, and that will impact the lives of Victorians moving forward. I'm also interested to see who are the parties to the case, to consider the significance or where the future precedent might apply. I can see that there is a plaintiff and a defendant, so I know this is a civil case. Now, I'm going to give you some background to the case to allow us to understand the judicial reasoning. This was a case where the plaintiff, Vicky Shields, was a tenant. Her house was in disrepair. However, it was in disrepair when she signed the lease, and the defendant was arguing that, who was the landlord, was arguing that they didn't have to make repairs because at the time the lease was signed, the tenant understood the condition of the house. So the tenant has sued, suggesting that the landlord needed to do something about it. Let's look for the key legal principles in place. Okay. The approach of Barron Park in relation to a covenant to keep premises in good tenantable repair. Now I'm thinking that because I can see these quotation marks, this is coming directly from Barron Park, endorsed in Proudfoot and Hart. Another case, so I'm thinking here that maybe there is some sort of precedent where Lord, Escher, MR state as followed. Now let's note that Lord and Barron are not Australian terms. So I know that that's not from the Victorian or an Australian court hierarchy, but is likely from the UK. Therefore, it may be the case that this is forming persuasive precedent, that in their judicial reasoning, I'm thinking that the judge in this case is using this as persuasive precedent to help guide their decision. What is the true construction of a tenant's contract to keep and deliver up premises in tenantable repair? Now, it is not an express term of that contract that the premises should be put into tenantable repair, and it may therefore be argued that, where it is conceded, as it is in this case, that the premises were out of tenantable repair when the tenancy began, the tenant is not bound to put them into tenantable repair, but is only bound to keep them in the same repair as they were in when he became tenant of them. Okay, so interesting here, they're talking about what are the obligations of the tenant rather than the landlord. But I wonder if the judge is going to take that principle and turn it on its head. Obligations of the tenant when it comes to, the house being in disrepair prior. But it has been decided, and I think rightly decided, that where the premises are not in repair, when the tenant takes them, he must put them in repair in order to discharge his obligation under contract to keep and deliver them up in repair. if the premises are out of repair at any time during the tenancy, the landlord is entitled to say to the tenant, you have now broken your contract to keep them in repair. And if they were out of repair at the tenancy, he's entitled to say you're breaking your contract to deliver them up in repair. I'm of the opinion that under a contract to keep the premises in tenable repair and leave them in tenantable repair, the obligation of the tenant, if the premises are not in tenantable repair when the tenancy begins, is to put them into, keep them in, and deliver them up in tenantable repair. Interesting. So this is putting the obligation on the tenant to repair the property. I also agree that the term good repair means tenantable repair or previously fit and suitable for occupation, and that while what amounts to good repair may be referable to the age and character of the relevant premises, it cannot ordinarily be qualified by the state of repair at the commencement of the tenancy, regardless of the state of repair. Again, the obligation to maintain rental premises in good repair imports an obligation to put them in good repair in the first place. The obligation of a landlord cannot be diluted by charging a low rent. So it is interesting to me, and what I'm thinking that the discussion here really centres on what it means for something to be in tenantable repair at the beginning and the end of the judgment. And what the judge here, I'm thinking, is that it's a fairly set standard regardless of the condition, and that obligations to put something in tenantable repair, either for the tenant or the landlord, exist regardless of the nature of the rent. That this is a fairly settled standard, and he's agreed with the persuasive precedent that there is a set or concrete understanding of what tenantable repair is, and that both the tenant and the landlord have the obligation to meet that standard. So let's see how the judge applies in this case. I accept that the proposition that a landlord's obligation under Section 68 may be qualified by either the condition of the premises at the commencement of the tenancy or the level of rent charged is inconsistent with the duty imposed at common law to take reasonable care to put and keep rental premises in a safe state of repair. As noted by the senior counsel for the tenant, it would be no answer to a claim that a landlord had breached their common law duty to maintain the premises in a safe condition to say the premises had been unsafe at the commencement of the tenancy. So here I can see the judge working from this persuasive precedent through to applying to the current situation and using the common law principle that we need to take reasonable care to put and keep rental premises in a safe state, therefore finding in favour of the plaintiff in this instance, and generating a legal principle that regardless of the condition at the beginning of the tenancy, the landlord has an obligation to take reasonable care to repair the property. So I found it really interesting how the judges used this case as persuasive precedent to guide their thinking, but ultimately to apply it in a slightly different way. It's really important that we don't simply stop at the end of the persuasive precedent, because that would give us an idea about what might be applied, but wouldn't actually give us the judicial reasoning in this case. Now that I've been able to unlock this, I can understand that this has set a binding precedent. I've identified the reason for the decision, the ratio decidendi, and I know how this will apply in future cases.